and inexpensively as possible. फिर 1976 में सुप्रीम कोर्ट ने क्या कहा, यह भी आप लोगों की जानकारी के लिए प्रस्तुत कर रहा हूं. At long last, the unfortunate and heroic saga of this litigation has come to an end. It has witnessed a silver jubilee. Thanks to our system of administration of justice and our carelessness and indifference to any drastic reform in it. Cases like this, which are not infrequent, should be sufficient to shock our social as well as judicial conscience and activize us to move swiftly in the direction of overwhelming and restructuring the entire legal and judicial system. The Indian people are very patient, but their indefinite patience, they cannot afford to wait for 25 years to get justice. There is a limit of tolerance beyond which it would be disastrous to push our people. This case and many others like it strongly emphasize the urgency of the need for legal and judicial reforms. A little tinkering here and there in the procedural laws will not help. What is needed is a drastic change, a new outlook, a fresh approach which takes into account the socio-economic realities and seeks to provide a cheap, socio-economic, expeditious and effective instrument for realization of justice by all sections of people, irrespective of their social or economic position or their financial resources. I would like to now identify the reasons why there is a long pendency of cases. In first 20 years, the laws which were enacted by Parliament and state legislatures were well crafted, well drafted, well debated. And thereafter, there is a gradual decline in the drafting of legislations at every level. Those draftsmen have gone. They have performed their second journey. And their successors are a poor replica of their predecessors. Bad drafting, lack of debate in the legislature is the main cause why poor legislations are coming out. The best example was recent. Few months ago, an amendment in the Constitution was moved and passed by one house of the Parliament. When it was sought to be presented in the second house, it was found that the numbering of the amendment is erroneous. How careless the department could be vis-a-vis a constitutional amendment illustrates how serious we are about the legislative instruments. That is one reason why large number of enactments are challenged in the courts and the courts are obliged to consider their validity and procedural defects as well. And the worst which happens every time is the utter carelessness with which the executive apparatus of the state deal with the new legislations. In last 20 years, hundreds of enactments have been passed by Parliament and state legislatures, resulting in growth of litigation in different quarters. I will give you two examples. Now the need in the world where legislations are enacted, there an expert exercise is undertaken to find out what is the expected litigation which will be generated by this new legislation and then create infrastructure for dealing with that particular litigation. In our country, it has seldom happened that when new legislation is enacted or some amendment is made which generates litigation, that corresponding increase in the infrastructure physical infrastructure and manpower is provided. One example is best. Negotiable Instruments Act. Common man does not know that the amendment made in the Negotiable Instrument Act till now has generated 44 lakh cases in the country. And no additional infrastructure. The same set of judicial officers who are already overburdened are fastened with the responsibility of deciding these cases quickly. And something which astoundingly came to my notice as Chief Justice of Andhra Pradesh, there are about 1 lakh cases are pending at Hyderabad at that time in 2006. Somebody sent a bundle of papers to me making a complaint that my case under the NI Act has been decided. Order has been passed in my favor, but it is not being executed for last 2 years. The bench issued a notice to the government why it is not being executed. An explanation was called from the court also why it is not being executed. And to our shock and surprise, the court informed that for last 2 years I am sending bailable and non-bailable warrants to the non-petitioner. It is not being served. Although the factory is running at the site, the person is always available at the site. The reports sent by the process server were found to be false. So the senior officer of the police was required to assist the court. He came and informed on the inquiry made by the court that there are 77,000 non-bailable warrants pending in Andhra Pradesh. And I have no doubt that this is true of all the high courts in the country, all the courts in the country. Nobody knows about this. This amendment created litigation without any additional infrastructure and no help from the bureaucracy, executive apparatus of the state, that is the police. How much time the High Court had to spend to ensure that these non-bailable warrants are executed, it's a matter of imagination for yourself. Second reason for increase in the litigation is totally arbitrary and unjudicious actions taken by the executive apparatus of the state, affecting almost every walk of the life of the citizen. 90% of the citizenry does not have the courage, does not have the capacity, does not have the financial resources to move the court against injustices inflicted upon them. They are too poor. And the goal of justice, which is first in the preamble of the Constitution, which we had decided in 1950, to give to every citizen justice, social, economic and political. Law students might know, common man does not know. Justice is our first goal. And after 65 years, we have yet to realize that particular goal. 90% of the people who suffer at the hands of the executive and even private individuals can't even think of knocking the doors of the court in the present day system. I give you one example. Land Acquisition Act 1894. Some of you might be conversant, the rest are not, that this act was enacted by the foreigners. In fact, way back in 1811, first law was passed in Bengal, followed by Madras, and then ultimately by the British Parliament. 1894 Act. There was no provision for payment of compensation at all to the landholder. First Amendment, provision for compensation to be determined by the court. Second Amendment, hearing to the landowner, and gradually went on. Their object was to acquire land for purely public purpose, for railways, for bridges, for roads. So perhaps people did not complain against them because they were providing facility to the common people. But after independence, and particularly in last 30 years, this act is no more used for public purpose. It is used for achieving private purpose. Land is ultimately given to private individuals. And what happens? I wish my young friends ponder over it. What happens? In our country, the agriculturists know only agriculture, no other profession, no other business, no other vocation, no other occupation. Most of the agriculturists. Now the private enterprise want land near the highways, near the state highways and national highways because it is convenient for them. The irrigation facilities available to the land in the vicinity of the highways, they are fertile land. They are acquired. Yes, in places like Haryana, Punjab, compensation is used. But in places like Rajasthan, Maharashtra, Karnataka, compensation is meager. They are paid compensation sometimes after a battle of 20 years. When the money value becomes zero, what he receives is zero. Because in most of the cases where the award by the reference court is higher, the state invariably challenges the same. I will come to that issue little later. The man is deprived of his land. His next generation does not know what to do. And beautifully in Haryana and Punjab, the best thing which is done, most of you do not know. Because the compensation has come, two things happen. The liquor shops are, temporary liquor shops are opened in the villages. And all vendors of beautiful cars open their stalls outside the office of the deputy commissioner, where the compensation is to be paid. They are attracted. The youngsters in the villages start purchasing SUVs and liquor. And at the end of 5 years, the compensation becomes zero. They do two things. The elders in the family land up in the slums in the cities like Delhi, etc. The youngsters, younger ones in the generation, take to the crimes because they have developed the habit of living a luxurious life. What happens to these persons who land up in slums? What a great thing the private enterprise does. They make announcement. We will provide employment to one member of the family. Nobody has thought of it. If thought of, not spoken, the landowner becomes the servant, to be kicked out of the job at the mercy of the employer. And one fine morning, it's based on experience, one fine morning, when a builder decides to build a multi-storied building, that slum is cleared by using bulldozers. And bulldozers, you must know, sitting in this air-conditioned hall, bulldozers in Chandigarh were used on 22nd of December night when the temperature was almost 1. And what happens to the people? You can only imagine that the child died in the cold because the bulldozers were used. There are several such instances where the executive takes action arbitrarily, unjudiciously, unmindful of the consequences. And second instance, which is recently affecting the nation across, from Kanyakumari to Kashmir and from Rajasthan to Nagaland, is the loot of natural resources. You must have read in the newspapers about the iron ore scandal in Karnataka. Karnataka is only cited, but Andhra Pradesh is equal. You must have read about the loot of other natural resources. And you do not know another loot is of uranium in Andhra Pradesh in district Visakhapatnam. What happens? How the burden on the court increases is that these matters are ultimately by some public spirited persons brought to the notice of the court. And if the court was to say, sorry, it is not our domain, we don't have to look into these matters, well, country will be deprived. Country has already been deprived of many lakhs of crores. So every apparatus which is under the constitution obliged to function for the people in public interest and for the people close their eyes and allows everything to go on. These types of matters ultimately place unbearable burden on the existing judicial apparatus of the state. I had the fortune or misfortune, I do not know, to deal with at least 2,000 cases in the Supreme Court relating to land acquisition and payment of compensation. And all of you will be shocked. In Andhra Pradesh, there was a matter where the acquisition took place between 81 and 1986. The compensation, not a single farthing had been paid to 2006. Not a single farthing had been paid. And now if the court says we will not interfere, where the people would go? This places unbearable burden on the court system. That is second. Third reason why the litigation has increased in our country. Sometimes I laugh by reminding myself of the example of 1974 or 75. In majority of cases, one of the eminent persons who is present in this august auditorium, Mr. Bhandari, I remember Mr. P.N. Bhandari, I had seen him working, but his creed has hardly 5% people in the bureaucracy who take decision positively and in the interest of the public at large. Rest, leave it. Let the man go to the court. Court will decide, we will implement it. Majority of cases, today's executive apparatus of the state shun their responsibility of taking decision. Naturally, matter lands up in the court. You can find the best example of it from this illustration, which is true. I was a young lawyer of 2 years age in the profession. In the morning, a client came to me with a brief, told me that it's a part-heard matter before a bench which was termed as the toughest bench in the Rajasthan High Court. He said, I asked him, why do you want me to do this case? You are already senior advocate. He said, my senior advocate has refused to do the case before the bench. Then he told me that I had gone to 2 other seniors, they also refused because it is pending before that bench. Lastly, he said, I had gone to your guru also, he too refused. So I asked him to get no objection from the comparatively senior advocate. He brought the no objection. I studied the file, filed an additional affidavit, and ultimately that case was allowed. After a few months, another client came, identical case, identical result. He too succeeded. Third came, I told him, why don't you make a representation to the government? He said, sir, representation doesn't work. So third case, I succeeded. Fourth case, I succeeded. Fifth case also, I succeeded. And in all, 117 cases were filed. When the last case was being argued, the court was kind enough to summon the original file. What is happening in the court? Why all these people had to come to the court? So he discovered that the Chief Minister of the state had recorded a note. Although the case is similar, looking to the finances involved on payment of salary in the particular scale, we should not take a decision on our own. Let the aggrieved person go to the court. If the court passes an order, we will implement the same. This is the status of at least 30% cases which should have never seen the doors of the court. And this is, my friends, is the cause, one of the causes why litigation has multifold increase in the country. Nobody wants to look into this cause. And then, so far as the state is concerned, which is the biggest litigant in our country. Biggest litigant. Every case decided at the first level, necessarily appeal should be filed as a matter of course. And my experience in the Supreme Court shows that in 70% of the cases in which state has come in SLP, the lawyer simply stands up, court observes, Mr. Counsel, there is nothing in your matter. He says, yes, my lord, dismissed. 70% cases which should never be filed in the Supreme Court. You will be surprised today, filing in the Supreme Court is 1 lakh SLPs. 90% of which are dismissed on the first day. But the burden is there. The poor judges have to go through pages after pages and thousands of pages every day. Almost every day, thousands of pages. One of my friends who is some of you might be conversant with his name, Gajendra Aldia. During December, he told me, can I come to the court? He had also many misgivings. So he went to the court along with me. He sat in my courtroom. He said, I will go after 1 hour. I go, okay, you can go. So he sat for 2.5 hours. During lunchtime, he came to my chamber and told me, I had a lot of misgivings. What amount of work you are required to do on Mondays and Fridays, it is just mind-boggling. How do you read these 5,000 pages? Well, I can't possibly explain all that. But the fact of the matter is that absolutely vexatious litigation is instituted by the state in various courts, including the highest court of the country. And you can imagine why there are increased areas in our system. Nobody takes a decision in this state. Perhaps that has become the mindset, that if I take a decision, and if there is a financial implication of it, I may be held up by my superiors. That is the psyche of the bureaucracy. Unfortunate, but true. And there is another important reason why the court's work increases, and why the courts are not able to effectively deal with all the pending cases quickly and expeditiously. If we had an effective and efficacious judicial system in the country, perhaps people would have got their dues. But with my experience, I can tell you, successive governments are determined that there is no effective judicial system in the country. They do not want. They want that we must keep this stick with us to beat the judiciary every time. They have an apprehension, at least in last 25 years or 30 years, they have an apprehension. Legitimate or not, I do not know. They have an apprehension that if there is an effective mechanism for dispensation of justice, our wrong deeds will be exposed. exposed very quickly. Once there is a delay in our country, people's memory is unfortunately very short. As like newspaper, you remember for 6 hours or 2 hours, all these incidents which happen of loot, etc., crimes, etc., you tend to forget because you are busy in other evocation, other works, etc. No administration wants an efficient judicial system. And that is the reason why, despite increase in the number of cases instituted in the court, there has never been an attempt to make corresponding increase in the infrastructure and manpower in the country. I will come a little later about the quality of the dispensation of justice. But the first is physical infrastructure. And you will be shocked to know that each high court in the country, and why high court, even the Supreme Court is seized with the petitions, with the complaint that adequate infrastructure is not being provided by the state for running the courts. One example is enough. In one of the states in the country, the court building was constructed 75 years ago. For last 7 years, the High Court has been writing, please get it whitewashed. Not done. High Court has been writing, please provide tables and chairs to the judicial officers and the litigants and the lawyers. No effect. 10 years. That is one state. This will be the condition in almost all states. One of my senior in the law college, who is now retired as a district judge, he told me he was in somewhere in Kota, some tehsil in Kota, there was no electricity at all. There was no courtroom at all. The court was held in the house of a peon where there was no electricity. Don't talk of good chair and table. Don't talk of almirah. He used to travel with the accused from the district headquarter or the sub-divisional headquarter to the tehsil to hold the court. His Jamadar will carry the bag and the files. The court will be held at that place in the peon's room. This is the sorry state of affair in every state today after 65 years. Interestingly, on creation of posts, very startling event took place in 2010. I was in Vigyan Bhavan. The then law minister of the country in public made an announcement. They were talking of the vision for expeditious justice, new vision. And he made a loud announcement. This is the habit of large number of public representatives to whom we entrust duties. We will create 15,000 posts in 1 year at the grassroots and will ensure that all the areas are wiped out within 3 years. 2010 to 2013, which will finish in next 5 days, there will be change of year 2014. We have yet to see creation of 1,500 posts in the country. And we expect every time that there are areas and there should be expeditious adjudication of cases. Please decide for yourself. And the problem comes at some places where the governments are compelled by the court orders to create posts, create infrastructure. The difficulty then comes. In modern times, again based on my experience, I can tell you that good lawyers, good from the point of view of earning money, fabulous earning, they don't want to join. They don't want to join at the grassroots. They don't want to join in the High Court.